Hi there. My name is Jeremy Newton, and the court case I was assigned was Sage v. Osseo Area Schools. This case was in regards to the Equal Access Act of 1984 regarding equal access for student groups to school resources. And this case was ultimately decided in the Eighth Circuit Court of Appeals in 2008. However, I will be focusing on the 2006 case, the preliminary case, because that had more to do with the initial and main arguments, the real meat and potatoes of the case. So, as some background, Maple Grove Senior High School in Maple Grove, Minnesota, recognized two kinds of student groups: curricular and non curricular. Now, curricular groups were allowed to communicate with the student body about their meetings and such via the school's PA system, the yearbook, the scrolling screen, and multiple other avenues of communication. In addition, these curricular groups were allowed to host fundraisers and field trips for their group. Now, SAGE, which stands for Straights and Gays for Equality, SAGE was recognized as a non curricular group and was therefore afforded none of these avenues of communication or event opportunities. Their communication with the student body was limited to a community bulletin board, and they were not allowed to host field trips and fundraisers for their group. The problem with this is that Sage alleged that other non curricular groups, they specifically named cheerleading and synchronized swimming, other non curricular groups had been given curricular designation by Maple Grove Senior High. And these groups were therefore afforded the expanded communication and event opportunities that were not given to non curricular groups. Sage alleged that this difference in treatment was a violation of the 1984 Equal Access Act. So they sued Osseo Area School District, which was the school district that Maple Grove Senior High was in. And the initial case was decided in the United States District Court of the District of Minnesota by the Honorable Joan Erickson. Judge Erickson granted Sage a preliminary injunction and ordered Maple Grove Senior High to afford Sage the same access for meetings, avenues of communication, and other miscellaneous rights afforded to groups referred to as curricular. Judge Erickson gave four reasons for this decision, which you can see on your screen. But the most important reason was that Sage, as the plaintiff, was likely to prevail. This is because Judge Erickson agreed with Sage that other groups that were non curricular had nevertheless been afforded more opportunities than Sage. Osseo Area School District appealed Judge Erickson's ruling, and they appealed to the Eighth Circuit Court of Appeals. The school district argued that the district court had not considered the school's physical education curriculum in naming cheerleading and synchronized swimming as non curricular activities. They further argued that the injunction was unnecessary because Sage did not suffer irreparable harm because they were not foreclosed from all avenues of communication. The appeals case was heard by the Honorable Levensky Smith, the Honorable Pasco Bowman II, and the Honorable Stephen Colleton, with Judge Smith writing the decision of the court. The Eighth Circuit upheld the decision of the district court. Judge Smith cited the Supreme Court's definition of non curricular groups as, quote, any student group that does not directly relate to the body of courses offered by a school, unquote. Judge Smith wrote, for example, that a French club would be a curricular group if a school offered French classes, but a scuba diving club would not be a curricular group even if the school offered general swimming classes. Judge Smith said that the definition of a curricular group did not, quote, include anything remotely related to abstract educational goals, unquote. As such, the Eighth Circuit Court reasoned that Maple Grove Senior High School's activities of cheerleading and synchronized swimming were, in fact, non curricular. The court therefore held that Sage was not being offered equal access to the same avenues of communication as these other non curricular groups. They also held that Sage did suffer irreparable harm via the restriction of their, quote, free speech rights and expressive liberties, unquote. Following the Following the Eighth Circuit Court's decision in 2006, Sage moved to make Judge Erickson, remember her, make her injunction permanent. Judge Erickson agreed. Osseo Area School District appealed, and in 2008, the Eighth Circuit Court of Appeals upheld the permanent injunction for the same reasons as their initial 2006 decision. Following this, Osseo Area School District decided not to further appeal the case, and the district abided by the injunction by changing their policy to treat all non curricular groups equally. The Eighth Circuit Court's decision clarified the precedent for determining what constitutes a non curricular group and upheld the tenets of the Equal Rights Act that all non curricular groups must be given equal access to communication and event opportunities. This is important for us to understand as teachers because more likely than not, most of us will be, staff guides or counselors, whatever you want to call it. Staff sponsors is the word I was looking for these extracurricular groups. And so we want to make sure that our groups that we are sponsoring are afforded the same access as other extracurricular groups, just to make sure that our kids are being afforded the same opportunities and rights as other students in other groups. So I believe that the Eighth Circuit Court made the correct decision in the the Sage versus Osseo case, and I believe that it's important for us as teachers to understand this topic of equal access to opportunities. So there are my sources for you there, and thank you very much for listening to my presentation.